Remember when pundits and MSM headlines claimed the censorship uncovered in the Twitter files fell flat and was overblown? Well, tell that to a judge, because yesterday, fittingly on Independence Day, a judge ordered some departments of the government and some government officials to stop using social media companies to censor dissent. And we've been following the case here on this show, Missouri versus Biden. Some of the plaintiffs include Dr. Jay Bhattacharya, Dr. Martin Kulldorff, and Dr. Aaron Kheriaty, who we've learned from the Twitter files were heavily censored by social media. And we actually have Dr. Aaron Kheriaty with us now to give us more details about this big win. Dr. Kheriaty, welcome to the show. Thank you so much for being here.
Thanks, Kim. Always good to be with you. And today is a good day because we have some good news for your audience.
Yes, I didn't know that anybody in the government worked yesterday on 4th of July, but apparently this judge did. And maybe they wanted to put this ruling out there on Independence Day to make a statement. And what a statement. I mean, this judge even said that this was one of the that this was a real dystopian Orwellian type of censorship that was going on.
Yeah, that's right.
And sided with you. So explain to us a little bit more, kind of give us the background of this case and then what happened yesterday.
Right. So Missouri v. Biden is a case that was filed by the state attorney general of Missouri and Louisiana, along with four private plaintiffs. And you named three of us. Jill Hines is the fourth plaintiff in the case, alleging that the government has been colluding with, pressuring, cajoling, coercing social media companies to censor disfavored information. And the private plaintiffs in the case who were censored most of us were commenting publicly on COVID-related issues, public health-related issues. And so that's what the initial complaint focused on. But the documents that we've obtained on discovery showed very clearly that COVID was only one of the many issues that the government was trying to censor and effectively censoring through their pressure placed on social media companies. So all kinds of issues, from Hunter Biden laptop to election integrity to literally monetary policy. The Department of Treasury was involved in the censorship regime. So the number of defendants in this case has grown. The number of federal agencies, I think we're up to a dozen or more federal agencies named as defendants in this case. And yesterday was a big advance. It was a victory for us because the judge granted our request for a temporary injunction. Basically, that's us asking the court, even before the case goes to trial, just on the basis of the evidence that we've uncovered so far in limited discovery, asking the court to intervene and basically halt particular government activities. And that's a big ask. Even if we win the case, that there's no guarantee that at this early stage of the case that the court would grant this kind of injunction. And basically what you have to have is, on the basis of the written evidence alone, even prior to the fact-finding process of the trial, the judge is basically saying, yes, the plaintiffs have a high likelihood of succeeding on the merits of their arguments. And he issued this 155-page, very detailed ruling saying things, as you mentioned, like the United States government seems to have assumed a role similar to an Orwellian Ministry of Truth. That's a direct quote from yesterday's ruling. And of course, as a plaintiff, you always like to think that something you're involved in, or I'm sure as a journalist, something you're reporting on has world historical significance. And so I have to be cautious about, claiming I'm involved in what's going to be a landmark case. But in this case, the judge in yesterday's ruling also said, like on the second page of the ruling, he said, if the allegations made by the plaintiffs are true, the present case arguably involves the most massive attack against free speech in United States history. The most massive attack against free speech in United States history, because previous censorship cases were usually one government actor, one agency pressuring one publisher, to censor a book or an article, or maybe a series of articles, or a particular journalistic source. What we're talking about here is the government censoring hundreds of thousands of ordinary Americans, tens of millions of times. I mean, because this is the first major case of its kind in the digital age, with the scope and the reach of social media and the number of Americans posting opinions on matters of public importance on social media. We just haven't seen anything like this before. And so this is the first victory in the first battle in a long war. This
Yeah.
case, most observers believe this case is going to go to the Supreme Court because both sides are going to appeal all the way up. The courts grind slowly. That's going to take a long time. The government's probably also going to appeal even this injunction, and so that'll go to the Fifth Circuit. So there's going to be plenty more back and forth. The
So
government's
sadly, it's
the
not
empire is
over.
going to strike back. Yeah,
Yeah,
no,
right.
it's
Yeah,
far from
the
over.
empire is. Yeah,
Uh,
unfortunately. This is a good part here. It says the plaintiffs have presented substantial evidence in support of their claims that they were the victims of a far-reaching and widespread censorship campaign, and this court finds that they are likely to succeed on the merits of their First Amendment free speech claim against the defendants. So there's a judge saying,
there
I
you
think
go.
you'll win. I think you're going to win this
Yeah.
case. And so then said that there would be this preliminary injunction that should be issued immediately. So even though this case may take years, by the time it sees its ultimate day in probably the Supreme Court, as you mentioned, um, that in the meantime, the government's not allowed to go and censor people. They can't contact social media companies and pressure them, like what we discovered in the Twitter files, to censor people. And this judge really laid out, here was this instance, here was this instance, here was this instance, and there was this
Yeah,
instance.
that's right.
What was interesting, though, about this is it does say that the plaintiff's motion for preliminary injunction is granted in part and denied in part. Can you explain the part that was
Yeah.
denied?
So fortunately, we got virtually everything that we asked for. The judge did make a point of carving out some exceptions where the government is permitted to communicate with social media companies on social media related content. And those exceptions are basically what the courts in the past have indicated are appropriate exceptions to the First Amendment free speech guarantees. So the First Amendment doesn't guarantee the right to post obscenity, doesn't obviously guarantee the right to engage in criminal behavior that's otherwise outlawed. There are exceptions involving things like a direct incitement to violence, and that's always narrowly construed by the court. The notion of violence and harm has been expanded
Right.
with recent rhetorical moves, but the actual rulings of the past indicated no, direct threat of physical violence against people or a group of people is not First Amendment protected free speech. So the judge carefully laid out those exceptions based on previous Supreme Court or other federal court precedents. And he did indicate that there are certain government officials that have the right to talk to social media companies about that kind of content. But interestingly enough, he named specifically some of the defendants named in the case. There were specific, not just agencies, but specific
Right.
government officials named in this ruling, where the judge was sending a strong warning shot across the bow that, look, we're keeping an eye on you. All the communication that you engage in now between you and the social media companies is subject to subpoena in this case as the case moves forward. And if we subpoena that information, find out that you are ignoring this injunction or disregarding it, that could be subject to criminal penalties, not
Yeah.
just civil liabilities.
I actually
And
want to
so
read some of these names. This is like because, and
it's
then
a
I have
who's
and
who
then
of the
yeah, I
censorship
have a
industry.
question
Yeah.
about this actually because it says so. These are the people. This is it is ordered that it is further ordered that the Department of Health and Human Services, the National Institute of Allergy and Infectious Diseases. Then they named Xavier Becerra, Dr. Hugh Anchenkloss, Yolanda Bird, Christy Choi, Ashley Morse. These are all like in the Health and Human
Yeah.
Services Director,
But
Digital
Sarah is
Engagement
a cabinet
Team.
member. He's the
Right,
secretary of
right. He's the
HHS.
secretary. Yeah.
Yeah.
They named Joshua Peck. They named Surgeon General Vivek Murthy, Catherine Deely. The center. Then he goes into the CDC people. Carol Crawford, Jay Dempsey, Kate. Yeah. So and then the United States Bureau and Federal Bureau of Investigation, so the FBI, and starts naming
FBI,
names through the FBI. The United States Department of Justice names even White House Press Secretary Karine Jean-Pierre, Stuart Dellery, You've got, so going through naming all of these different names, also the Cybersecurity and Infrastructure Security Agency. So that's CISA. And that there's actually a good point on this one that I'm going to bring up. So remember CISA here for a minute here. It says United States Department of Homeland Security, and then goes through some of the names there. The Department of State, and then it says all these people and these agencies are hereby enjoined and restrained from taking the following actions as to social media companies, and then lists the things that they're not allowed to do. So that is meet with social media companies for the purpose of urging, encouraging, pressuring, or inducing any manner the removal, deletion, suppression, or reduction of content containing protected free speech posted on social media platforms, specifically flagging content, urging, encouraging, pressuring for companies to change their guidelines. So they're not allowed to change their pressure them to do that. They can't email, call, send letters, text, or engage in any communication of any kind with social media companies to pressure them to reduce certain types of content. So they go through, you can't threaten, pressure, coerce to reduce postings of protected free speech. So there's 10 different things he says you're not allowed to do. But here's where it gets interesting, though, because then it says it is further ordered that the following actions are. So this is where he says these are not prohibited, right? These are the ones that you're allowed to do still, because there's a certain level of protection you're talking about. Like, they can still inform social media companies of postings involving criminal activity or criminal conspiracy. They can contact them or notify them about national security threats, extortion, or other threats posted on its platform. They can contact them about cyber, like illegal campaign contributions, cyber attacks against election infrastructure, anything that threatens public safety, anything that like government speech promoting government policies or views on matters of public concern. So they can tell them this is the official statement from the government of what we think of this. That's fair enough.
Exactly. Yeah.
But here's where it gets interesting. It says that this part is denied. It says it is further ordered that the motion for preliminary injunction is denied as to the following defendants: the U.S. Food and Drug Administration, U.S. Department of Treasury, U.S. Election Assistance Commission, U.S. Department of Commerce and Employees, Erica Jefferson, Michael Murray, Wally Adeyemo, Stephen Frid, Brad Kimberly, and Kirsten Muthig. And this is where the eyes start to pop, and they're saying that it is further ordered that the motion for preliminary injunction is denied for the Disinformation Governance Board and its director, Nina Jankowicz. What? Shouldn't she be the first name included in this?
Well, So first of all, they no longer exist. So that you can't enjoin an entity that no longer exists because it was shut down and she was fired.
Okay, so that's why they're saying the Disinformation Governance Board is not a part of this, because it's not.
Here's what's going on here. Yeah, the judge is not saying it's okay for all of you people to go ahead and continue censoring. What he's saying is basically these are all people named as defendants in the suit. I think what he's saying is, on the basis of the evidence submitted so far on limited discovery, we have enough evidence. We've met the legal threshold for a temporary injunction against all the people that he named.
Okay.
We haven't yet, on limited discovery, met the very high legal threshold for a temporary injunction against those other defendants, those other people that you
I hate that
named.
it has to, so many of us, we just want, especially all these COVID lawsuits that have been going on, and it's always, we want the cases to win like blanket, like the government's not allowed to do this thing, and they don't.
Yeah, well, here's what you have to understand, Kim. Yeah, here's what you have to understand. An injunction is not a precedent-setting ruling.
Okay,
it is always specific to the facts of this case.
Got it.
And it's in place so long as the case is being tried. And then at the final ruling of the case, the government could issue the court could issue a permanent injunction.
Yeah.
That would be broad and blanket, applying not just to the defendants in the case, but a precedent setting applying to anyone else who's similarly situated. Right. So what the judge is trying to do here is to make the injunction, I think, appeal proof. In other words, if the government appeals to the Fifth Circuit and says, well, they don't have enough evidence to enjoin these people. Yeah. Right. Then the injunction gets thrown out entirely, rather than the injunction basically saying, okay, we have enough evidence right now for me to slap the wrist of these defendants. And obviously the other defendants should recognize that they are on notice. Okay, maybe the plaintiffs haven't presented enough evidence yet to enjoin you, but everything you're doing is subject to subpoena as this case moves forward. And the judge has also made it clear that he's going to grant additional discovery. He's going to grant additional depositions. He's going to grant additional subpoena powers in our case, and that what he's allowed so far is basically what he's allowed for that initial stage of the case.
Okay.
So all of that has to be
that
understood.
Right.
This is a long process, and it has to do with the fact that this isn't the court giving a final ruling in our case. This is the court saying, so far, very early on, you have provided enough evidence for the court to do this and to name these people specifically. But of course, it should have a chilling effect on not only all the defendants named, but anyone else in the government who thinks now it's my job to engage in this kind of behavior.
I just don't like seeing that they carved out Nina and that disinformation. They were like, well, okay, it doesn't pertain to you. I get it. It doesn't exist today, but Joe Biden can make it exist tomorrow. And then suddenly Nina and the Disinformation Governance Board can go around censoring because they're now exempt from this. I mean, they got carved out. Like, you don't, okay, you could still, okay. So I do want to mention back to CISA. So this is the Cybersecurity and Infrastructure Security Agency, and this is what got Matt Taibbi in trouble when he was testifying to Congress, and he made the mistake of saying CISA when he meant CIS, S-I-C, I mean CIS, which is the non-government body, right? It was like a contracted private entity.
Right.
So that makes me wonder, ultimately, when this goes all the way, you know, wouldn't the government, and I don't know if you guys are thinking about this and building this into the ultimate case, but wouldn't the government just work around this whole thing by saying, okay, then we'll just contract private companies to go and contact this, like CIS, to go and contact social media on our behalf?
Well, that is in large part what they have been trying to do, not only with CIS, but with the so-called Virality Project, with the Election Integrity Partnership, with the Stanford Internet Observatory. The University of Washington has an outfit that's engaged in social media censorship. And I call these things quasi-private entities because, first of all, they're all government funded. Mm-hmm. And second of all, there's like a revolving door, a rotating door between government and those quasi-private entities of basically it's all the same players involved, moving back and forth between them, such that the line between public and private becomes increasingly blurred. But the court in previous cases, of course, we're making the argument in this case, the court in previous cases has made it very clear that the state cannot outsource its own illegal activity to private actors. In other words, trying to create this sort of cover is not going to give them adequate legal cover, because if they're communicating to the social media companies via these intermediaries, then that constitutes a form of entanglement that would amount to what the court calls state action, right? So this whole case hinges on whether the government's behavior constitutes state action. Their defense is that we're just being your friendly neighborhood kind of government agency, offering you information. Hey, you might want to look at these accounts. You might want to look at these posts that might be violating your terms of service. And we're not telling them what to do. Mm-hmm. The problem with that argument is, number one, it's not true. We have plenty of evidence that they were engaged in pressure, emotionally abusive relationships. Some of these emails between Rob Flaherty of the White House and Facebook executives are just horrifying. But even if that wasn't, we know that was happening, but even if that wasn't happening, the court has also made clear, and the judge in a previous ruling on our case, the judge outlined 5 different ways that the government could be involved in state action when it comes to censorship. And overt pressure and coercion was only one of them. Various other forms of entanglements, various other forms of involvement is also problematic from a First Amendment standpoint. Right. And it has to do with the asymmetry of power, right? The fact that if you're getting in bed with these private entities and, just being helpful to them, in the background, even if it's left unsaid, is you better do what we say or else, or we're really in charge here because we can regulate you out of existence. We can make life difficult for you through taking away certain Section 230 protections that the
Right.
social media companies rely upon.
Right.
So that defense is not going to fly for both of those reasons. One is that the government has been overtly pressuring and coercing. But two, even if they weren't, there's four other ways that the government can be implicated as a state actor in this case. And all four of these things are things that we've documented very clearly are happening.
Yeah. So the Justice Department has issued their little statement on this. They're obviously not very happy, and they say that they're reviewing the injunction and will evaluate its options in the case. They said that this administration has promoted responsible actions to protect public health, safety, and security when confronted by challenges like a deadly pandemic and foreign attacks on our elections. Our consistent view remains that social media platforms have a critical responsibility to take account of the effects their platforms are having on the American people, but make independent choices about the information they present. So they're almost saying, well, we didn't really, we're not the ones. They are independent. They made independent choices. Yeah, but obviously what we saw on the Twitter files that they were absolutely pressuring them, especially in particular when they were carting them in front of Congress and then questioning them and saying and threatening them with removing Section 230. That is when we really saw the pressure was on, the message was clear. And then when the government said, hey, by the way, here's something we don't like, these companies felt like they needed to do something about it. So this was just a preliminary injunction, meaning they just can't, they're not allowed to do this for the time being. These certain entities, certain people can't do certain things for the time being. But where is the case at right now? What's the next step for the bigger part of this case?
So besides the government appealing this injunction and us going through that process of an appeal to the Fifth Circuit and possibly to the Supreme Court just on the injunction, once we get through that hurdle, the case is going to proceed to trial. And that is going to be the stage where we're making oral arguments on on our specific complaint and not just what we've done so far, which is oral arguments on the injunction. So we will be in court.
Do you know
testifying. Well, no, we don't know. We don't know when, because likely it's going to depend on how long it takes for us to go through the appeals process for the injunction and what the government is going to do next. The ball's kind of in the government's court. So we'll see that these things the courts grind slowly, but they do grind. I anticipate this case could actually take years, but the injunction is also good because it puts everyone on notice that while this case is being tried and appealed and reappealed, that if the government continues to engage in this behavior, the court could intervene, and that could really set them up for serious problems and compromise their ability to convince the court that they haven't been engaged in illegal behaviors.
It's been amazing also to see how the free press, the supposed free speech press, has actually been handling this case. The headlines like this is Washington Post, judge blocks U.S. officials from tech contacts in First Amendment case. The Trump-appointed judge's move could upend years of efforts to enhance coordination between the government and social media companies. They're acting like this is such a bad thing. This injunction is a bad thing, and the free speech press is claiming this. That, oh, what a terrible thing.
The Times and the Post are framing it as a partisan issue.
Yeah.
They're framing it as an impediment to fighting disinformation. And of course, sensible Americans should understand that this is not a partisan, it's not a left, right, liberal, conservative issue, Democrat, Republican issue at all. It's a legal versus illegal issue. The only question is, did the government systematically and in many, many, many instances violate the highest law of the land, which is the United States Constitution, thereby trampling the constitutionally guaranteed free speech rights of all Americans? That's the only issue at stake here. It's got nothing to do with partisan politics. And basically yesterday's injunction is the court indicating that, it looks like based on the evidence presented so far, that's exactly what the government was doing. And that's a serious problem for all
Of
Americans.
course, this press would be championing if this injunction if it was Trump who was being accused of
Yeah,
pressuring social media companies to censor liberal ideas and
that's
liberal
right.
thoughts. They would be saying, "Oh, this is a win for free speech," but they've made something that really is honestly fundamentally American. Free
Yeah.
speech, fundamentally American, and they've turned it partisan, and that is the craziest thing I feel like I've seen in my lifetime is this attack
It's
that we saw
really,
all throughout
it's
COVID
really
and
very
now.
surreal.
Yeah, it is.
And they don't seem to worry about what if the shoe is on the other foot at all, which I think is short-sighted, and sees power in purely instrumental terms and has no regard for the rule of law,
Yeah.
including constitutionally guaranteed rights. I mean, it's very, very worrisome that we would have a press that would characterize this case in this way. I mean, you can argue about the evidence in the case. You can argue about legal thresholds and whether we presented a compelling argument
Yeah.
that unconstitutional behavior is happening. Fine, let's debate that. But that's not what's going on in the press.
No.
What's going on in the press is an attempt to reframe a free speech issue into something that it's not.
Yeah. Well, just more craziness that we've seen over the last few years. Dr. Aaron Kheriaty, thank you so much for joining us. Thank you
Thanks,
for
Kim.
pursuing this lawsuit and getting a real, so far, a win. And I project further wins in the battle for free speech and anti-censorship. So really appreciate it. Thank you so much.
Thanks, Kim. Appreciate your coverage.